Morning, everyone, or afternoon, as the case may be. Greetings from Vancouver, British Columbia. My name is Joe Weiler, and I'm a professor emeritus at the Peter A. Allard School of Law at the University of British Columbia. I'm co-director with my friend and colleague John Ritchie of the Anti-Corruption Law Program. Our program is a joint working partnership that provides continuing professional education, and the partnership is of three entities: the Center for Business Law at Allard, Transparency International Canada, which I have the privilege of being vice chair, and the Vancouver Anti-Corruption Institute, which is a new component of the International Center for Criminal Law Reform, which is also based at UBC. So this is the 30th seminar or conference in the anti-corruption law series in our 6 years of operation. It's the first in 2022. Last year we had 9 webinars. And it's an example of how 3 leading organizations, all with different core competencies, but a common mission in fighting corruption, how they can take collective action to work together to provide top flight continuing professional education services, where we bring together leading experts in the anti-corruption field to teach each other, which is what we're going to do today, and teach each other about the best ways of fighting corruption and promoting integrity. I want to give special thanks to Dr. Carol Liao, who is the director for the Center for Business Law, and her crackerjack technical team of Stephanie Lee and Austin Darling for their assistance in putting on our programming. Also to James Cohen, who is the executive director of Transparency International, and our chair, Suzanne Cote-Freeman, to Peter German at the Vancouver Anti-Corruption Institute, and to Norm Baldwin, who's now a senior member of the management group here at the Anti-Corruption Law Program. I also want to thank in advance our panelists, for putting together or putting their time at our disposal, for today's session. It's now my privilege to turn proceedings over to Roy Cullen, who's going to be our moderator today. Roy is a long-standing supporter of the Anti-Corruption Law Program. He's a former member of Parliament of the Government of Canada, initially elected as a member of Parliament in 1996, and then re-elected 4 times as a member of Parliament, and before he retired in 2008. And while he was a member of Parliament, Roy served on some very important roles, senior roles in our government. He was chair of the House of Commons Standing Committee on Finance, parliamentary secretary to the Minister of Finance, secretary to the Deputy Prime Minister, and secretary to the Minister of Public Safety and Emergency Preparedness, all of which is very, very relevant to our discussion today. While working with the Ministry of Finance, Roy was very active in helping to design and implement Canada's anti-money laundering regime. And in his spare time, he wrote and published a book called The Poverty of Corrupt Nations, which was published in 2008. And since he retired from the House of Commons, Roy has been very active in an organization called GOPAC, the Global Organization of Parliamentarians Against Corruption, where there is former parliamentarians are collaborating in their efforts to fight corruption and particular focus on money laundering. So it's a great honor for our program that Roy has agreed to moderate our distinguished panel. So again, thanks to Roy, our panelists, my colleagues here at the Anti-Corruption Law Program. They've worked very hard to put this together. And now it's my privilege to turn things over to Roy. Roy, over to you.
Well, thank you. Thank you very much, Joe. Bonjour tout le monde et bienvenue à tous. First, I'd like to congratulate the Anti-Corruption Law Program for the great work that they do in the fight against corruption. And I thank them for organizing this webinar. We do know that those guilty of grand corruption are leaving millions of citizens behind in poverty. And Joe mentioned some of the players involved at the anti-corruption law program, so I won't repeat that, but just to say it's been very much a team effort to bring this together. And I want to thank again the panelists for making time from their busy schedules to be part of this program. We have a good turnout for the webinar, so I want to thank all the participants for your interest in this topic. And but first, as Joe mentioned, the anti-corruption law program is connected with the University of British Columbia. So we would like to acknowledge with gratitude that its campuses in Vancouver are situated on the traditional unceded territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations, while UBC's Kelowna campus is in the territory of the Salix Okanagan Nation. I'm sure you will join me with thoughts and prayers to the people of Ukraine in the courageous defense of their homeland. This is a very exciting time for me that the notion of prosecuting the perpetrators of grand corruption is back on the public policy radar. The Global Organization of Parliamentarians Against Corruption, or GOPAC, an organization actually that was founded in Canada in the House of Commons for the plenary session in the year 2002. It's an organization that I've been involved with and active for the past 20 years. And in and around 2013, GOPAC mounted a program to find a way to prosecute the perpetrators of grand corruption in an international court. Research was undertaken, a GOPAC task force of international experts was launched, and our CEO at the time, Akash Maharaj, who actually may be participating in this webinar today, made a presentation at the UN promoting this project. Ultimately, GOPAC was not able to pursue the initiative given the massive personnel and financial resources that would have been required to advance this agenda. But here we are today, ladies and gentlemen, with another chance. During this webinar, we will discuss how the term grand corruption is defined. There is some complexity to this. However, this would need to be addressed, of course, before an international anti-corruption court was launched. One thing we do know, however, is that petty bribery is not the same thing as grand corruption, and that corruption is generally defined as the misuse of public resources for personal gain. So we'll come back on that later. Now today, we have assembled a really powerful panel for you, and I'm looking forward to a dynamic and productive discussion. The panel discussion will be very interactive. As moderator, I will pose some questions to each panelist and will invite comment from the other members of the panel. Questions from the floor, in other words, all of the other participants in this webinar, will be considered, their questions will be considered for presentation to the panelists. But do keep in mind that I will be allocating up to 1/2 hour for questions from all of you after the panelists have completed their dialogue. Questions directed to the panel should be transmitted on the Q&A icon on the Zoom screen. The chat feature can be used for other communications. Now, the panelists today have very different views on the need to establish or the desirability of forming an international anti-corruption court. We have done this deliberately so that we can have a full and lively debate of the issues. After all of the panelists have completed the first round of questions, each panelist will be offered a few minutes to comment, critique, rebut, elaborate in any closing remarks. At the end of the panel discussion, I will introduce you via Zoom to a young Nigerian woman, Olutanji Ademiju, or Addie as she prefers to be referred to as. Addie is a PhD candidate at the University of Victoria, and she will describe how an international anti-corruption court would be received in an African country like Nigeria and how it would work. I should say also that the Anti-Corruption Law Program views this webinar as the first step in a sequence of dialogues on this important and complex governance issue. Links to background information on the issues and status of an international anti-corruption court have been previously made available to all of you if you wish to tap into that. Now, let me introduce our distinguished panel. Alan Rock is President Emeritus at the University of Ottawa by virtue of his distinguished two-term service as President and Vice Chancellor at Ottawa University. He is currently a professor in the Faculty of Law at the University of Ottawa. Mr. Rock served as Canada's Minister of Justice and Attorney General for Canada, as Minister of Health and Minister of Industry and Infrastructure. He was Canada's ambassador to the United Nations and more recently a visiting scholar at the Harvard Law School. Welcome, Alan.
Morning.
Matthew Stevenson is a professor of law at Harvard Law School, where he teaches administrative law, legislation and regulation, anti-corruption law, and political economy of public law. Prior to joining the Harvard Law School faculty, Professor Stevenson clerked for Senior Judge Stephen Williams on the U.S. D.C. Circuit Court, and for Justice Anthony Kennedy on the U.S. Supreme Court. He is editor-in-chief of the Global Anti-Corruption blog and the co-host of Kickback, the Global Anti-Corruption podcast. Welcome to you, Matthew. Peter MacKay served as a member of Parliament in the House of Commons in Ottawa for 18 years, and during that time, he had a number of portfolios. He was Minister of Justice and Attorney General of Canada, Minister of National Defence, Minister of Foreign Affairs, and Minister responsible for the Atlantic Canada Opportunities Agency. He also chaired the Government National Security Committee for many years. Prior to politics, Mr. MacKay was a Crown attorney. He is currently working as a strategic advisor to Deloitte Canada, my old alma mater as well, and he is with the law firm of McInnes Cooper. Welcome, Peter. Juanita Olea Garcia practices law in Colombia and Germany. She is currently chair of the Victims of Corruption Working Group at the United Nations Convention Against Corruption Coalition. She has served as a member of the International Expert Panel at the Open Government Partnerships Review Mechanism. She has served as chair and vice chair of the UNCAC Coalition, UNCAC being the United Nations Convention Against Corruption, and as a member of the International Review Panel of the World Bank's Stolen Asset Recovery Initiative, or STAR, as it's known as, among other board participation. She is a professor at universities in Colombia and Germany. Welcome, Juanita. Now let's get into the discussion. First question directed to Mr. Rock. Alan, my question has two parts, so I'd ask you to please leave a bit of time in your response for the second part. You were on record as supporting the creation of an international anti-corruption court. Is this truly an idea whose time has come? And if so, why? And how would it combat grand corruption?
Thanks, Roy. It's nice to see you again, my old friend. And I'm delighted to be on this panel with such knowledgeable people. I look forward to learning from them as they make their interventions. In answering your question, let me make as my starting point the observation that anybody proposing a major change to the international justice architecture should approach the task with a strong sense of humility. It is a massive task, and there are challenging questions and complex issues to address. And I think one of the great values of this morning's program, or this afternoon's program, is that we'll have a chance to look at some of those issues and generate innovative ideas for how to confront the challenges. And that's why I think this is such an important program. In answering your question, let me first of all state the case. Why do I believe that it would be advantageous to create an international anti-corruption court, and then address 4 issues that commonly arise in relation to the subject. First of all, why a new court? Well, the scale of grand corruption at the moment globally is enormous. It's very difficult to estimate, but the Global Financial Integrity Organization estimates that developing countries lose to corruption an amount 10 times greater than they receive in development assistance. The money's diverted from everything from public health initiatives to infrastructure to infant mortality. And existing methods are manifestly not succeeding in stemming this flow of corruption. Despite everything that's being done, it continues at those astonishing levels. And corruption is at the root of so many evils that we confront in the world today. In fact, the way I became involved in this, Roy, is through my work with the World Refugee and Migration Council. The close nexus between grand corruption and forced displacement, causing refugees and internally displaced, is very clear. Corruption does not flourish because we lack laws. As my colleagues on the panel will tell you, 189 member states of the UN have ratified the United Nations Convention Against Corruption. And that convention requires them to enact domestic laws, rooting out things like bribery and money laundering and embezzlement. So we have plenty of laws and we have norms well established, contrary to corruption. The problem is enforcement, because the worst offenders not only are kleptocrats who run the state, but who also control the police, the courts, the whole enforcement mechanism. And it's not in their interest to enforce the laws on the books. I also observed that in creating the anti-corruption court, we're not starting from zero. There's already a sturdy infrastructure in place and growing. The International Anti-Corruption Coordination Center, with 8 of the world's largest economies and with additional associate members, has since 2016 established methods for states to cooperate in anti-corruption efforts. There's a financial action task force that does the same. And of course, since 9/11, states everywhere have put in place mechanisms to trace and track money, particularly to avoid the funding of terrorism, but for other reasons as well. The advantages of the International Anti-Corruption Court are to lend a coherent and a coordinated effort through a single court to enforce the laws in question, a global effort. It would have complementary jurisdiction, meaning that it would only act if the state affected by the corruption was unable or unwilling to do so. It would hold the promise of holding kleptocrats to account, introducing a measure of deterrence, and finding a way to return the stolen assets to the victim country or repurpose them for the benefit of the population. And a key point, Roy, it would level the playing field for business in countries like ours, in Canada, countries that cannot pay bribes in foreign jurisdiction, but are competing with companies that do. This would level the playing field. And for that reason, the idea is getting more and more support from the private sector and from business. Briefly, let me talk about some of the questions that arise in this connection. Kleptocrats and their countries won't join the court. Well, no, they won't. But that's not the point. Kleptocrats don't keep their money at home. They put it in foreign jurisdictions with stable banking systems like Canada, Switzerland, and throughout Europe. If those countries are members of the court, we will have jurisdiction to enforce the laws against the kleptocrats. What about the cost of an international anti-corruption court? The International Criminal Court has been terribly expensive. Would we spend the same for an IACC? I argue that we would not. That the International Anti-Corruption Court can learn the lessons of the ICC. In fact, one of our big supporters is Justice Richard Goldstone, who just completed a 20-year review of the ICC. We can learn from his observations about how to make this a lean, efficient, and effective court and avoid some of the overspending we've experienced with the ICC. And a key point, remember that corruption annually costs an untold amount of dollars. If we could save just a percentage of that through the International Anti-Corruption Court, it would more than justify the investment. So I know it's a controversial proposal, and there are issues of difficulty of proof that we have to work on. And I have some ideas there, but I'm anxious to hear from my colleague panelists about how we can tackle that and other questions that arise. I'll stop there just in summary saying, I believe that given the scale of this problem, it's a global problem, there should be a global response. Everything we're doing now is not succeeding. And so if there's going to be an onus in this discussion, surely the onus should be on those who defend the status quo because it is manifestly failing. Let's get together and form an international body that can tackle the scourge of corruption on behalf of all humankind in an organized and effective way. Thanks, Roy.
Thank you, Alan. Well put. Now, what role, if the world was to proceed with an international anti-corruption court, should Canada play a leadership role? What kind of role should the government of Canada or the Canadian institutions play? Canada played a major role in the landmine ban treaty in the 1990s, and I know that our colleague Lloyd Axworthy and yourself and others really led the charge on some of that. How could the government help with this initiative if it got a lot of traction, which it's getting now?
Well, first of all, the government of Canada ran for re-election last fall on a platform that included supporting the creation of the International Anti-Corruption Court. The opposition party had the same plank in their platform. So both parties are united on the need for the court. Secondly, there's something called the Canadian model in terms of international innovation. You've referred to the Landmines Treaty, which was stalled in the UN process. Lloyd Axworthy, through his innovative methods, was able to harness the energy of a global coalition of NGOs, make progress outside the UN system, sign up friendly and supportive states, and bring it back to the UN when he had the critical mass needed to achieve the treaty. The same thing was done as we sought and achieved unanimous approval in 2005 of all UN member states for the responsibility to protect against genocide. The Canadian model provides a way for us to start with a small group of like-minded states with and in partnership with NGOs, build on that outside in, and produce ultimately enough agreement to produce a treaty. The Dutch government yesterday announced that they're in. Colombia and other countries have expressed very supportive statements on behalf of the court. We believe that working with the massive number of NGOs around the world, together with support of governments, we can use the Canadian model to bring this to fruition.
Thanks very much, Alan. I'm going to move now to Matthew Stevenson. Matthew, in 2019, you and a colleague, under the auspices of the U4 Anti-Corruption Resource Center, a great source of work on anti-corruption, you co-authored a report entitled An International Anti-Corruption Court, a Synopsis of the Debate. Now, this report is quite comprehensive and deals with the benefits of an international anti-corruption court and the concerns about such a court. And in the report, you summarize the argument that as an alternative to such a court, why not continue to work with and within existing structures and programs to pursue a range of alternatives for fighting corruption and impunity. Now, we want to get back to all of these arguments, but firstly, could you describe the concerns that are out there about the political feasibility of an international anti-corruption court? And my question is two-barreled, so we'll start with this one. Matthew.
Yeah, so first of all, thanks to you, thanks to the whole program for inviting me to participate in this. Thank you very much to my fellow panelists. Although my perspective is somewhat different from Alan's and that of some of the other people who are going to speak, I think this is a really useful conversation to have. And although I remain skeptical regarding this particular proposal, I think it's extraordinarily productive to have these conversations. And so great. Thank you very much for having me here. So I'm trying to figure out the best entry point into responding to your question. And I think maybe the way I want to frame my remarks is to respond to something that Alan said that I want to resist a little bit in terms of the framing of the case for the anti-corruption court. So Alan said correctly that grand corruption is an enormous and extremely costly problem, a statement with which I entirely agree. I could not agree more strongly. And then Alan says, well, look, therefore, since the status quo is not working, we've got the people who don't like this idea need to kind of prove that it's not a good idea, otherwise we're just sticking with the failed status quo. And here's why I want to resist that. So I think that framing suggests, first of all, that the failure of the status quo to eliminate grand corruption means that no progress is being made or could be made in a meaningful way in the absence of this institutional innovation. And it's also operating on the presumption that the International Anti-Corruption Court would have a substantial impact in addressing the problem. And the framing almost suggests that if you had the court, the problem would go away. But Alan didn't quite say that. But I want to highlight that I think the right way to frame the question has to do with the marginal benefit, the additional progress in confronting the problem of grand corruption that would be achieved through investing resources in the form of time, attention, money, et cetera, in an international anti-corruption court, as opposed to the other things we could be doing with that time, attention, money, resources, etc. Right. So that's the way I would think about the issue. And that's why in that report that you mentioned that was co-authored with an excellent researcher at the U4 Center, Sophie Schutte, who's very expert in these matters as well, the report also emphasizes a whole range of other things that can and should be done to tackle the problem of grand corruption, some of which Alan mentioned, right? Stronger anti-money laundering rules, finding, freezing, and ultimately seizing the proceeds of corruption or other unlawful activity, working to strengthen capacity within countries to promote the effective prosecution of corruption crimes in countries that want to actually do something about this problem. There's a whole, we could have a long conversation about this. There's a whole panoply of policy responses that could be used. And, you know, they're not shiny, they're not sexy, like they're not the kinds of things that, you know, people have a whole conference organized around the big new idea. I kind of feel like people are constantly looking for the big new shiny idea. And my own study of the fight against corruption over time has led me to believe that it really is a long, slow slog with no silver bullets. So I think I want to use that as a general way to frame my skepticism of the court, because I always worry in these events and talking to people who are very sincere about fighting this problem that skepticism of the court will come across as a lack of seriousness about the problem or dismissiveness of new and innovative approaches. And that's not what I'm trying to convey. I'm entirely in agreement with Alan and others regarding ends and objectives. My skepticism arises from concerns about means, in particular, whether this is the best use of time, energy, money, and political capital, if we're serious about fighting grand corruption. So now to connect this to your question about political feasibility, you know, I don't think the only objections to the court have to do with feasibility. I do think those are extremely important issues. However, the first generation of proposals for this court seem to think that it would be very much operating on the model of the International Criminal Court, such that in order to be subjected to the court's jurisdiction, a country would need to join the court. And so in my early writing on this is one of the things that I focused on is unrealistic, right? Like, how can you expect the kleptocratic governments to join on to the court? They're not going to do it. And if they don't do it, kind of what's the point? Now, what's interesting about Alan's initial presentation is it sounds like many advocates for the International Anti-Corruption Court have moved off of that initial idea, which involved using all sorts of sanctions and pressure and so forth to compel resistant kleptocracies to join on to a court that would then prosecute their leaders. So Alan has an alternative suggestion, which is, well, we can get jurisdiction over the kleptocrats because the kleptocrats' money is going to be in countries that have signed on to the jurisdiction of the court. There's some very complicated international law issues that arise here. I want to highlight this. I don't believe, though I could be corrected if I'm wrong, that in the International Criminal Court, you can get jurisdiction over individual defendants simply because they have assets in a country that is a member of the ICC. I don't believe that's permissible. I'll also point out that finding the assets of the relevant people and showing that the product of corrupt activity is itself extremely challenging. And if we can do that, there are other mechanisms that we have at our disposal, such as freezing and seizing the assets. I definitely think it's going to be very complicated and delicate legally and politically, even for someone like me who's not like a super sovereignty hawk, to arrest the leader of another government on the basis of the fact that they have assets in Canada or the UK before there's actually been a crime proven. I think that strikes me as very complicated and hard, not the kind of thing where you can snap your fingers and say, now we've tackled grand corruption. Those cases are going to go on for years with uncertain outcomes. I just am worried that that's not going to be the most productive approach to go after this very serious problem. I would also highlight, I think this is an important point that sometimes gets overlooked. If this is a court, the prosecution has to prove its case. And proving these grand corruption cases is not easy. I've spoken to friends who are former prosecutors who've worked with things like the International Criminal Court. In some ways, proving war crimes is easier, right? Unfortunately, you have dead bodies, you have witnesses, you have a lot of information that you can use to prosecute. Prosecuting complex financial crime is complex. And I'm just not convinced that creating an international court is going to lead to substantially greater progress in fighting this very serious problem than more aggressive and effective deployment of tools that we already have at our disposal could enhance through other means. So I don't want to go on for too long. I just want to express my concern or my skepticism that there's sometimes this impulse to what I think of as the judiciary ex machina, right? Like the politicians, lawyers, others sometimes like this. If there's seeming like an intractable problem, that if you just created like some international body like a court, it would sort of swoop in heroically and solve it. And I don't think the history with these institutions is that encouraging. So Alan said, and I think this is right and good, that we should learn from the history of the ICC. But again, it's not like we can study that history and snap our fingers and magically make the problems go away if you're creating a new body on the same model. So I remain open-minded. I'm open to persuasion. But it's been years and years since I've been engaged with people about this proposal. And I still feel like a lot of the fundamental practical and political difficulties with creating this institution have not been adequately addressed. And they're often addressed with all appropriate respect to Alan, and that's not a personal criticism, but they're often addressed by some version of, but isn't this a big problem and hasn't the status quo failed and therefore shouldn't we do this? And that's not a coherent argument, right? You can't evade legitimate concerns about whether something is going to work just by repeating that the problem is big and that the current measures aren't working. I think I need more than that, and I have yet to hear it.
Okay, thank you, Matthew. I think you basically covered the second part of my question, but are there any interventions by panelists for the remarks by Alan or Matthew at this point?
Well, while it's fresh in our minds, can I address one thing Matthew said? I think he, with respect, misconceives the concept of jurisdiction of the court. What I said is, if the kleptocrat who is running a country and stealing from it, and the country is not a state member of the court, but the kleptocrat puts his money on deposit in a Canadian bank, then the existence of the illicit funds in Canada, which is a state party to the court, would give the court jurisdiction to launch an investigation, not to arrest the kleptocrat by any means, but to start the investigation, which could well result in the indictment and arrest of the kleptocrat. So, and it's not one cannot analogize to the ICC on apples and apples. It doesn't work that way. The ICC jurisdiction is organized differently. But I wanted to just speak to that point right away before any time went by. The other thing I might say is that Matthew says that the International Anti-Corruption Court, one of its problems will be that corruption is hard to prove. Well, corruption is hard to prove now under existing procedures in national courts or anywhere else. It's always going to be hard to prove. I would have thought it would be an advantage in facing that difficult task to have a global court with connections with Interpol and other international tracing and tracking regimes, and through mutual legal assistance have all countries working on this in a coordinated way. I just wanted to make those points quickly before time went by.
Okay.
Can I make one very, very quick response to that?
Yeah.
And just the first part, because I know other people need to speak. But if Canada becomes aware that a foreign kleptocrat has money that's a product of illicit activity parked in Canada, Canada can already go after that, launch an investigation, prosecute them under existing Canadian anti-money laundering law.
Yep.
And freeze the assets, they can seize the assets, and if the assets are the product of illicit activity and they can trace it to the kleptocrat in question, that person can be charged in absentia with money laundering offenses.
Yep.
So this is why I'm a little bit, and it's hard to prove, and it's hard to get that person under under jurisdiction so they can actually be arrested. You can freeze and seize the assets. But this is the point I'm trying to emphasize. Like, what's the delta? What's the marginal benefit of having the international court? You already said on the second part about facilitating international assistance. I have thoughts on that too, but I'll save those for later. I wanted to highlight that you do not need an international court to prosecute people who are storing the proceeds of illicit conduct in a jurisdiction like Canada or the United States or the United Kingdom. Those laws already exist.
Roy, I'll have to answer that later because others want to.
Yeah, well, money laundering, yeah, I got a question on that for later, but Not sure that's working as well as it could, but nonetheless, before we move on to Peter and Juanita, I have a couple of questions from the floor that maybe from James Cohen, the Executive Director of Transparency International Canada, and Errol Mendes. They're sort of related, basically saying, if you look at, and I think one of the former chair of TI has just come up with a book arguing that, you know, we've really missed the boat by allowing a lot of this corrupt money to flow into, I'll call it the West, you know, whether they're banks in Panama or Montreal or wherever, and that's where we should have the focus. And the other related question is that maybe the idea would be to focus, if you look at what's going on with the kleptocrats in Russia and the amount of money they've been moving, a lot of it into the UK, maybe the idea would be to focus on some of the countries that are particularly horrifically bad on this and sort of narrow down the problem. I know that the United Kingdom, they just tabled legislation that requires beneficial owner declarations for properties. And not too long ago, they brought in this unexplained wealth order. I don't know, that doesn't seem to be working all that well, but does anyone want to tackle that? In other words, why don't we just deal with the money that's flowing into the West and try to tackle that and maybe focus on some of the worst countries in the world?
Juanita wants to speak, Roy.
Juanita, yes, please.
Yeah, thank you, Roy. I may be jumping my horses. I haven't, thank you for the invitation. But I would like to jump directly on that because I think that's one of the immediate things at hand to do. We need consistency in the way the world deals with kleptocrats and with these kind of people. We cannot say on the one hand that we are creating an international court to fight corruption, but on the other hand, continue to handle diplomacy with a double standard and with hypocrisy at the end of the day. Whenever there's money, whenever there's trade, whenever there's a national security argument, countries tend to look away. And that cannot continue to happen because that's what's keeping the laws not being implemented. That's what's keeping the actual existing instruments not being used. And that won't change with an international court. That can only be aggravated. We're seeing now the painful effects of kleptocrats that have not been kept at bay. It's too late. So we don't have the time to discuss to build a new building, a new institution, when we have already instruments at hand that we immediately can use. That money could have been rejected. The only way to deal with kleptocrats is to suffocate them. And suffocate them by not letting them use and invest those assets who are all over the world. Now, we're thinking they are in the West. That's already passed. Those assets are already moving elsewhere where we cannot make questions, where we cannot introduce controls, in countries where we cannot discuss or agree on an international court. So I do think that point that James Cohen raises is crucial and is at the heart, consistency is at the heart of the other options of the things we need to do and we need to do now.
Thank you, Juanita. I want to get on to Peter MacKay, and we'll come back to some of these questions, I'm sure, because I have some follow-on questions later. But Peter, there's broad bipartisan support, as Alan mentioned, in Canada for the establishment of an international anti-corruption court. Integrity Initiatives International is very engaged on this issue. Maybe you could describe for the audience what Integrity Initiatives International is all about. And could you describe how this bipartisan support developed in Canada and how has it evidenced itself? And I have a second part of my question, if you can leave a bit of time for that. Peter.
Sure. Thanks very much, Roy, and to my colleagues, and my thanks to UBC and all the participants. I think this is a timely discussion and demonstrative of the need. And I'll come back to this point, is what we're seeing, unfortunately, unfold in Ukraine. There's certainly a rampant example of corruption in both countries, and there is knock-on effects that have led us to a critical juncture and arguably have exacerbated the situation and contributed to the war and the conflict. I want to begin by saying one of the arguments here is that we just simply try to buttress existing institutions and we don't need a new one. And I must say, as somebody who, like participants here, has spent time in Parliament and institutions, worked in the justice system, it's to me, it's not a one or the other. I think that this is incremental, as Professor Stevenson said. It's something that is inevitably going to happen over time and require resources and a lot of coordination and cooperation. And what we don't want, frankly, the antithesis of what we would seek to achieve here would be to create a more bureaucratic, gummed up system that doesn't lead us to greater accountability, that doesn't lead us to the prosecution and restitution stage within the pursuit of grand corruption and those kleptocrats. To answer your question, Roy, on what Integrity Initiatives International is really about, is a nonprofit organization with great credit to Judge Mark Wolf, Massachusetts court judge, who, along with others, has been working in this space for a very long time. He and others that have worked on the prosecution side, or the district attorney's side in his case, were exposed, I think, early in his career to both corruption, let's call it in the private sector, but in the public sector, where both elected and non-elected individuals were involved, and highlighting the instances of government implication here, of using public funds for a completely inappropriate purpose, and to diverting that necessary funding away from critically important issues and causes that demand those resources. And that is some of the inextricable discussion here, is that grand corruption is a cancer that spreads, and it impacts on human trafficking. It impacts on illicit trade of drugs and weapons and chemicals and many other terrible byproducts of that money being pulled out of public causes. I would pause for a moment and emphasize that in the pandemic, we have seen massive amounts of money in response by governments globally to the necessity to float the economy, to respond to those in need, to salvage companies, but with very little oversight, little of the traditional parliamentary oversight that we would have in Canada and that we have seen in other countries, because it was bypassed. There was a necessity to accelerate things quickly. And so it has created, in my view, an atmosphere of more vulnerability. I would say the same in the debate around green energy, and absolutely staggering amounts of money that were committed coming out of Glasgow, the Paris Climate Change Accords. And where is that money destined for? In many cases, some of the most impoverished countries in the world that have the least ability to provide the oversight necessary to see that the money gets to the intended recipient. So again, I've dodged your question a bit, Roy, but this group, Integrity Initiatives International, has been doing work in the space with other organizations, trying to sort of help to coordinate. And that is something, to repeat Alan Brock's emphasis on a necessity to coordinate the effort in a way that makes it more efficient. I would add to that a singular point, that it will, I believe, lessen the load or thin out the docket at the ICC. It will allow some of the necessary focus to be placed on grand corruption and the kleptocrats, because, quite frankly, as it should be, a war crime, and hopefully we will see Vladimir Putin one day appear in the dock at The Hague, along with his generals. But there is a prioritization that happens in every court. We have the necessity to move certain cases forward in Canada because of changes that came out of our Supreme Court that require certain indictable offenses to proceed ahead of other cases, which is a problem everywhere. There's a backlog, there's a clogging up of our system. And so, to counter Professor Stevenson's point a little bit, this isn't about creating another sometimes monolithic system. This is intended to buttress the work of the ICC, to allow a particular and more laser focused attention on grand corruption. And with, I think, the lessons learned, and at the risk of being repetitive, as Alan has said, there are lots of lessons learned. We've had the ICC in place now for a sufficient time that this could be done in a much more efficient and effective way. Final point, Roy, the nonpartisan element of this, I think, is a clear recognition, certainly in Canada, but around the world in other countries, including the Dutch, European Union countries. We are seeing a recognition that we cannot afford in the global community to allow this to go on. There is a critical urgency to this. And you are going to inevitably have to plug into an international anti-corruption court some of the existing agencies. It won't work in isolation. You're going to have Europol, Interpol, our FinTrack system in Canada, other tracking systems, anti-corruption policing efforts are going to have to be coordinated. I would argue, in the vernacular, it's sharing the load across a broader infrastructure of criminal justice and enforcement and accountability. And I think the nonpartisan element is, quite frankly, refreshing. We've seen massive divisions in all of our countries, in our political systems. And the fact that the two major parties in Canada committed to it, had it in their platforms, and now the government, to their credit, have brought it into their mandate letters for our Foreign Affairs Minister, that's encouraging. And I think that there is little argument that this is an idea that has been around and been debated long enough, and it needs to be actioned now. And I believe, personally, Canada would be a good host country for such a court.
Thanks very much, Peter. Yeah, but seeing bipartisan support like that is certainly encouraging based on my experience as well. And Alan, I'm sure. Now, the second part, and I'm not sure we're going to solve this today in this panel discussion, but it seems to me that the governance structure of an international anti-corruption court will be a paramount consideration for success. And we've talked about the various models that we could draw and look at: the International Criminal Court, the European Court of Human Rights, and the United Nations International Court of Justice, who at this moment are investigating possible crimes against humanity by Russia, I believe. And there are other institutions. How would you look at structuring the International Corruption Court? How would you get the support and participation of the international community, and who would pay for this court?
Is that
Peter?
direct?
Peter, that's to Peter, yeah.
Oh, well, certainly the host country is going to bear much of the cost. There could certainly be the plea put out to other participating nations, much as we've seen in other organizations, to pay a form of dues and the cost associated with the administration of the court. There's also, I think, the very important element to this, and that is an element of restitution and reallocation of some of the seized assets that would result from the prosecution of kleptocrats. You're going to want to turn the majority and the balance back to the victims. And we have in our system in Canada a Victims' Bill of Rights that speaks to some of the allocations of restitution and how we are to do that. And I think you can transplant that, as in other countries, sort of like taking the engine of one system and putting it in another. We don't need to reinvent systems of restitution, but there is obviously going to be a cost associated with it. The United Nations, the United States pays a lot of the freight. The same in The Hague, and there is a natural, I think, global responsibility that a country assumes when they take on such an initiative. We've referenced already Canada's role in terms of the Landmines Treaty. I would add, our leadership on apartheid and peacekeeping. And there are other examples where Canada reputationally, I think, has also benefited. But I believe an anti-corruption court, needs a host country that is not only respected, but seen, and this is an important consideration, but seen to have a functional and quite frankly, an integral system with integrity. And Canada, has its blemishes. We have to be quite forthright in admitting that. And we've made changes in the past, including inserting deferred prosecution agreements, et cetera. But the cost associated, Roy, I think would be spread out around participant countries with a percentage of assets seized going directly to the cost of administration, much less, I think, than the ICC.
Good, thank you. Thanks, Peter. Any of the other panelists want to jump in quickly before we move on to Juanita? Seeing none. Senora Olea Garcia, there are those who say that we should build upon existing policy structures and institutions. In fact, we've touched on that slightly earlier with yourself and Matthew as we fight grand corruption. Could you comment on that position? Can we build on existing structures, policies, institutions, or should we be looking for new and different ways to try to combat grand corruption? I have a follow-on question, but let's start there, Juanita. Hello, Juanita? Are you unmuted? Yeah.
Yes, I am. Thank you,
Good.
Roy. And thanks again to the Anti-Corruption Law Program for the invitation to take part in this conversation, which I'm sure will continue. This will not be the only conversation. I hope this is a very important and a complex topic. The answer to your question is yes, but let me take a step back. This is a beautiful idea. The idea of creating an anti-corruption court is beautiful. It speaks to the expectations of the kinds of things we want to hear. So you won't hear me telling you it's a bad idea. But you will hear me telling you it's not useful. You will hear me telling you it's a distraction. And along the lines of what Matthew says, in a world where resources and energy is scarce, we need to focus on things that work here and now. And this is an idea that would have been good, excellent, 20, 30 years ago. At the moment the UNCAC was being signed and the ratification process was starting and the way corruption played out back then. But it's not an idea suitable for the present nor for the future. It's built on a different type of world order. And another question that you made, Roy, at the beginning, could Canada have a role? I wouldn't say in this, but in changing the trend in international diplomacy when it comes to corruption, I would say yes, and please. And this is a moment where we need Canada the most in full-fledged, with all its history and its tradition of mobilizing human rights and humanitarian issues all over the world, but with the right focus on something that provides more impact. Let me mention a little bit why, and perhaps at some point I can get into a little bit of the list of good options of what Canada could do, because the list is long and it's good. You know, there's reasons on merits on the court that have been discussed. Matthew mentioned some, Alan also mentioned some of them, and they have been addressed: the jurisdiction, the geopolitics, etc. Those are practical issues. I have a few other issues that I think are less easier to deal with, and at least on paper, although paper allows for everything. The first one is that this idea plays out well on the weaknesses of current international diplomacy. Let me tell you an anecdote. In the year 2019, I attended, on invitation of the Foreign Ministry of Colombia, a regional meeting of foreign ministries to galvanize this idea. I went there, we discussed, but what I heard astounded me. What I heard was many Central American countries and some South American countries supporting this idea, not because of the potential merits of the court, which we could discuss and have different opinions on, but because this court, because they didn't want the model of the court of the Integrity Commission that was installed in Guatemala. And they saw this court and this idea as a way to avoid that. So how do I read that? There is a group of countries that know how to play out the international world, recognize in this idea, an idea that may work in 10, 20 years, they're not there anymore, as a way of distracting all the energy from some ideas, from some other mechanisms that indeed work. And that's what worries me. So one would ask, and one needs to ask, what are the intentions of these countries supporting this idea, supporting it so much? What's happening? So we need to be careful about that. And looking at that reaction, I really worry. The other issue is that there's a false logic that we need to check ourselves with and be critical about. There's a false logic that an international court would compensate for rule of law weaknesses or judiciary weaknesses in certain countries. Quite the contrary. It needs those institutions even more than anything else. It needs them strong. You know what Matthew mentions, the difficulties of gathering evidence for economic crimes. It is actually a fact. According to the OECD in a report they produced 2 years ago, 80% of the cases, of the corruption cases, are resolved by settlements because it's hard to come back, to come up to evidence for a final trial. An international court will not solve that issue, will make it worse, will make it more difficult because you need local evidence gathered locally to be able to ground these cases. Also, the issue of creating savings or restituting funds. These are local assets. They're placed locally. That won't be possible without local cooperation, no matter how good our will and our dreams are in establishing a court like this. Another argument is that, you know, it seems to me there is a flavor about this idea that evocates corruption as bribery, as only bribery, or kleptocrats as, you know, the Netflix kleptocrats that we're now used to see in the films or in the newspapers. But corruption today is much more complex, is much more silent, is a network of things, much more difficult to prove. And I don't see how an international court would be able to prosecute and sanction this kind of corruption that we have today. That's why I say, you know, 30 years ago, different. Today, I don't think so. But perhaps the most important argument for me, and where I think Canada has a strong, you know, place to play a good role, is that this idea insists on a false separation between corruption and human rights. In a way, it's a contradiction, because what I hear Alan and Peter is emphasize the scale of the problem, the gravity of the issue. And this is precisely because corruption, every act of corruption, causes a human right violation. Collective human rights, sometimes individual human rights, but every act of corruption is a human rights violation. If we build a court separate from everything else, we're just creating a separation that doesn't exist when we need to put the issues together more than ever. And where Canada, which is with its tradition, promoting human rights, defending human rights, standing, Canada has been a country that is there when one needs it. Canada has played an amazing role in defending and supporting civil society in the UNCAC processes, when everybody else is excluding it, which is a paradox too. So Canada has an incredible opportunity to promote and to fortify the connection of those issues, not the separation of it. So that's why I'm worried. But you had another question, Roy.
Okay. No, thanks, Juanita. Some good points. Before I get into the second part of my question, you mentioned this Guatemala court model, and I know, Matthew, in the report that you co-authored, you talk a bit about that as well. I wondered if both of you, maybe starting with Juanita, could describe this Guatemala court model for the participants in the webinar in particular, and how could that be replicated elsewhere? How does that work?
I'm careful with replications elsewhere. Solutions and approaches like this are very country specific. In Guatemala, what is called as the International Commission of Impunity, for its acronyms in Spanish, was active for about 12 years. It was a combination of an international court placed locally and anchored very well locally with local prosecution authorities. So it managed to achieve a level of prosecution, a number of cases that had never been seen in Guatemalan history. It was also part of the claim and part of the peace process that Guatemala had experienced. It was so successful that it was kicked out, that they were expelled. And that tells us the level of success that instrument played. I don't know if, Matthew, you would like to add something about it.
The one thing I do think it's important, and Juanita, correct me if I'm wrong about this. It's possible I'm misremembering, but I believe it's so-called CICIG, the Guatemalan Commission Against Impunity, was not a court. it had investigative functions, but actually it had to work partly in cooperation with the Guatemalan prosecutorial service, but also the cases that CICIG investigated were brought in Guatemalan courts. And none of this is, I'm very much, Juanita, in general, as you know, in agreement with your view that supporting these kinds of institutions is, in my view, more promising than trying to create a global or international institution. Partly because you can do it in a more tailored way to the particular circumstances and needs of the particular country. But I do think it's important to clarify, since an earlier, I think, Roy, the way you set up the question, you mentioned this as an example of a court. It wasn't a court. It was principally
that's true.
There are examples of international involvement in judicial institutions that are supposed to address corruption. The most prominent, I'm sort of sad to think about it right now, was Ukraine. So it's different because in Ukraine, the court, their anti-corruption court was not run by foreigners, right? There were not international judges. However, at the urging of Ukrainian civil society activists, the design of that institution, which was supposed to specialize in corruption offenses, was such that the selection of the judges to serve on that court would have the involvement of a panel of international experts, essentially because domestic Ukrainian civil society activists didn't trust the normal Ukrainian appointment system to keep the wrong people off of the court. And the Ukrainian civil society activists formed an alliance with international partners, most importantly, the International Monetary Fund and the European Union, who put sufficient financial pressure on Ukraine to create this new institution. So this is the kind of thing I'm talking about. I mean, I think we don't want to sound overly, naive, like, oh, it's not a big problem. Again, I yield to nobody with respect to how seriously I take grand corruption, but I do resist a little bit when people say things like, the status quo isn't working, nothing can be done, as if like there's no progress anywhere. There are a lot of examples of the international community working with domestic activists and reformist politicians to make substantial progress.
Okay.
Countries that, and Guatemala is one example, and Ukraine.
Thank you, Matthew.
Prior to the wars.
Peter had his hand up, Roy. And
Okay,
then
Peter, yes, yeah.
Just very quickly in response to some of Juanita's very, very salient points, but there's issues here of capacity and complexity. And, following on what Matthew just said, I think there's a lot of agreement on just how big this problem is. I mean, that's why it's called grand corruption. There is massive implications that we've talked about already, but on the complexity side, this is why, in my estimation, one of the arguments that holds the most water is the necessity to really up the game of the anti-corruption movement here. And that means not just the resources, but a much more coordinated approach. A process that allows for the sharing of information. We are seeing criminality now getting into the stratosphere, literally, because of cyber. The ability to divert responsibility, the ability to the misconceptions and misdirection, and the lengths that criminals can go to now to avoid detection. Alan referenced the moving of money. And we know that Bitcoin and other forms of cryptocurrency can move mass amounts of money in spite of all the best efforts of law enforcement to improve their response and their tracking. When we're talking about some of the most challenged nations on the world, Afghanistan comes to mind. And, my reflections on what we could have and should have done better collectively, we, the West, was in addition to military and development, we should have sent a battalion of judges and lawyers there to help them try to build the capacity of their own judicial system, their own justice system, because that would have gone a long way. Ukraine, obviously at a different scale, could have benefited from more effort from the West in that regard as well, which may have buttressed some of the vulnerability that evolved. Final point on the capacity issue. The complexity is one thing. The capacity comes back to the ability of enforcement and accountability and underpinnings of our justice system around denunciation and deterrence and holding those responsible to a higher level. And I'll cede the floor to Alan here to talk about the responsibility to protect. But much of what is indoctrinated in the responsibility to protect is the recognition that many countries didn't have the capacity to protect themselves, their citizens. And without that capacity, that's where an international anti-corruption court can pick up that cause, can appropriately respond, can apply the resources. And this isn't, of course, to be clear, this is not about saying it's entirely comprised of Canadians, not at all. You know, we're talking about an international body that is going to have the influence and the input and the decision-making within its institution from all participating nations.
Thanks, Peter. Alan, you wanted to say something?
Very briefly, I know Juanita wants to speak as well. I'm indebted to Juanita for the rich regional perspective she provides, and to Matthew for the point he makes about the good things that are happening already. I'm suggesting that we're both saying the same thing. A new international anti-corruption court could harness and deepen the efforts being made regionally against corruption and provide greater coordination and depth to those efforts. We spoke a few moments ago about the design and management of the court. There's nothing to say that there can't be a global court with regional capacity, building on the energy in Central and South America, building on the initiatives in Asia or in Africa, deriving the energy from local centers of activity and commitment, linking it to a global capacity with expertise, with the sharing of information, with jurisdiction that makes sense. So as we design this court, let's make sure that we don't obliterate, but rather we gather up, use, and consolidate the energy. Now, Juanita mentioned that the regional representatives were reluctant to support the Guatemala initiative and more likely to go for the international court because they thought it would take the attention off them and they'd be saved. Well, let's look at that from the other way around. Maybe the international court could strengthen and consolidate what's going on regionally to the detriment of the crooks who are trying to escape its jurisdiction. And as to Canada's role, I see an integral link between efforts against grand corruption and efforts to protect human rights. The taking of this money, the corruption, is a destroyer of human rights. It undermines them. And I think one of the integral purposes of such a court, which would be spelled out in the preamble and its enabling statute, is to protect and advance human rights by working against corruption. And the last thing I'll say is, of course, proving anti-corruption cases is difficult. It's difficult now. It'll be difficult with an international anti-corruption court. I don't accept that it's going to be more difficult if there's a coordinated global effort harnessing regional energy and commitment. It's going to be as difficult as ever, but surely one of the reasons it's hard is getting evidence, is coordinating efforts, is communicating with authorities to pool information about the track of people's activities and where they're putting their money. And so I believe that by making it a global institution linked to regional efforts, this would actually help us advance the efforts against corruption. Thanks, Roy.
Thanks, Alan. Before moving to Juanita, and Juanita will have to be very quick response because we need to move on, but I should just say that, Alan, your earlier point about utilizing regional courts was absolutely the position that the Global Organization of Parliamentarians took as well, that there's the headquarters court, but there are regional courts that can be, capacities can be helped to be augmented and working some of these processes through the regional courts. Juanita, if you jump in very quickly, and then we're going to move on to some other line of questioning.
Yeah, 2 points very quickly to Alan and Peter's points. I work a lot on organizational development with concrete organizations implementing change. And one rule of thumb is, in a complex system, introduce simplicity. So the coordination that you say, that we will achieve it does look like that, like there would be a lot of coordination, but I'm astounded to hear still, years after working on this issue, how difficult it is for law enforcement officials to pick up the phone and call a colleague. We saw that happening well in the Odebrecht case. It's still an issue for any other case. An international court will only make that a bit harder. the point, we do agree on a lot, though. We agree the scale of the problem is hard. This is a crime against humanity. It causes human rights consequences. And to add to the idea that Matthew gave, you use anti-money laundering law to file a case immediately. I give you another one, particularly since you mentioned that Canadian judiciary is strong. Canada has universal jurisdiction. Be the first country to use universal jurisdiction to file a case of corruption against a kleptocrat. You can do that now. You have the evidence. You would have the evidence. You could do it immediately. And you wouldn't have to wait 5, 10, 15 years to negotiate.
Okay,
Or
thanks.
not even, you wouldn't even have to wait to have the assets of that kleptocrat in Canada. On the basis of the principle of universal jurisdiction of criminal law, you could launch it now, together with a case on AML that Matthew suggested. So I would imagine that would be an amazing act of Canadian leadership, and a very, very good first step to draw more attention to these courts. If this is what Canada decides it's important and where it's the energy they should be putting on, that would be a real demonstration of power.
Thank you so much, Juanita. And thanks to all the panelists. Now, as anyone, you've done a bit of wrap up commenting, but does anyone have something they'd like to add before we move on to some more specific questions?
Yeah, just one point. I didn't respond to something. I mean, Matthew made some very good points, and I respect them. There's one I wanted to respond to. It's, you know, if Canada were to discover tomorrow that a crook has stolen from a foreign treasury and put the money on deposit in Canada, we can freeze it. And he's right. In fact, there's legislation before our parliament that would permit the government to go to court for an order confiscating and repurposing the assets. So we could even do that. But the separate and different question is whether Canada would actually initiate a prosecution of the kleptocrat who actually initially took the money. As Juanita says, we could exercise universal jurisdiction. The point of an IACC, an International Anti-Corruption Court, is that it would be a repository of expertise and experience. Prosecutors, investigators, accountants, those with sophisticated ability devoted to the single purpose of tracking down and prosecuting these wrongdoers, so that Canada might well freeze the asset or confiscate it under domestic legislation, but might look to an international body with expertise to conduct the investigation and prosecution. And I mean, Canada is the easy case, but if the money is on deposit in a state party in a country which did not have the capacity to initiate an investigation or prosecution, there's where the International Anti-Corruption Court would be of particular value. So I say that we can develop a court. We can, when we come to the point of negotiating the Rome Statute for the IACC, build in design features that will accommodate the effective activities that are going on around the world, put them in a global context, and provide, I think, an instrument that the world badly needs. Thanks, Roy.
Okay, thank you, panelists. I'd like to move on now to some more specific questions. And there's a question from the floor from friend and colleague Jamie Hammond, which is sort of related to this question, and that is, would an international anti-corruption court act as a deterrent to grand corruption, and would it signal to the world that world leaders are serious about fighting this scourge? Now, my own view is that you would have to deliver more than that, but would it at least do that? And I know, Matthew, you talked about that in that report that you co-authored. Would you like to speak to that?
So again, I'm skeptical. I'm skeptical in part because in order for there to be a substantial deterrent effect, the probability of detection, prosecution, punishment has to be high, right? And otherwise, even if the court ends up doing something, and I've got some skepticism whether it would end up doing anything, even if created, it's kind of like getting hit by a bolt of lightning, right? Deterrence, there's a lot of research on this in other contexts, but not in this context because we just don't know enough, but that suggests that more than the severity of punishment, the idea that sanctions for wrongdoing are certain or at least predictable and swift is really important. The probability of getting punished is high. I'm skeptical that simply creating the court will strike fear into the heart of kleptocrats everywhere. Because they're sophisticated people and they've got to understand that actually building these cases, getting the evidence, getting jurisdiction over them, all the stuff that has to happen is extraordinarily difficult, particularly in the absence of cooperation in their home jurisdictions. Now, I want to acknowledge what I think is a very important point. Symbolism is important, right? I don't want to denigrate that. I think that it's certainly possible that if the international community collectively expresses its opposition to grand corruption in some form, that could send a message. But I'm skeptical that this is the way that message needs to be sent. I think there are a lot of other ways the international community can send that message, in part by, and I keep coming back to some of these same themes, cracking down on the dirty money flowing into Canada, the United States, other Western financial centers, like vigorously enforcing the laws that we've already got, I think would do a lot more to deter the bad guys, especially, and I'll come back to the point Juanita made, we're talking about how much deterrent effect would there be after the court is created. That's the way you frame the question, Roy. But like, given that it's going to take, I would say, an infinite amount of time to create this, because I don't think it will ever happen, but even the optimists seem to think it's like we're talking a decade. I don't think talking about creating international court right now is going to have any deterrent effect on anybody, which is not a reason not to do it, but like, I'm skeptical.
Thanks, Matthew. Juanita, you wanted to jump in, or?
Yes, I would add to Matthew that in my view, in my experience, from how I know them, criminals don't behave rationally. So, you know, there was a recent anecdote. It would be funny if it was not real. Switzerland confiscated some luxury cars from Obiang and sold them back to him.
Okay.
He was enjoying them
Yeah.
2 weeks, two months afterwards. So, you know, we have to be careful with this. I mean, on paper, your argument looks strong. Yes, of course, it would scare people out. It's out of, but in practice, it doesn't work that way. In
Okay,
practice,
thank
what
you.
we need is consistency.
I'd like to get into
of
the
implementation of the laws.
the question of money laundering, and Alan, you know, you talked about that a bit, and Canada was the last G7 country to bring in an anti-money laundering regime, and so we had the advantage of drawing on a lot of experience, and we benchmarked the mandate and the resources, et cetera, et cetera. But as you know, in Canada and British Columbia, it's sort of surfaced in British Columbia. We've had some problems with money laundering, and it doesn't make me terribly proud. And I've been involved in trying to recommend what needs to be done. But Raymond Baker, who formed an organization in Washington, DC, entitled Global Financial Integrity, very recently, he put together an international task group of experts to look at FinCEN. FinCEN is the United States Financial Intelligence Unit housed in the Department of Treasury. And basically the question was, are these anti-money laundering rules and policies and regulations working? And they basically concluded, and if it applied to FinCEN, it would apply really to most anti-money laundering agencies around the world. They said it really isn't working that well. And what they suggested was a Manhattan-like project to really brainstorm what needed to be done to deal with this problem. And they talked about techniques using artificial intelligence, blockchain technology. In other words, they were basically concluding that we need to do something different. Now, who would like to comment on that? Do you think that that's a valid argument? I mean, it seems to me that in a lot of these institutions we have now, and I've been working on this myself for many years, I'm not sure that we're seeing that corruption is on the decline.
Well, Roy, I don't think it's an either or. It's not either we create an international anti-corruption court or we do something effective domestically about money laundering. We have to do both, as Peter was saying. And I think we have to fess up to the fact here in Canada that we can do a lot better than we have been in relation to money laundering. The fact that we came to mind when Matthew raised money laundering is evidence that we're getting a reputation as a place that could be better than it is. So And the government has now introduced a proposal for beneficial ownership disclosure. We've also strengthened FinTrack and other mechanisms nationally, but there's more we can and should do. As to whether corruption is getting worse, it's very difficult to know. One has the sense, but finding the dollar value for corruption is traditionally very difficult, and one shouldn't overstate it, but at the same time, we have to be realistic about it. Let me say smuggle in a word about deterrence here, because it was talked about. Right. Everybody's critical of the International Criminal Court for all the usual reasons, but I have to tell you something. When I traveled in Africa in my capacity for the UN, and I dealt with the warlords in northern Uganda with the Lord's Resistance Army. When I took part in the negotiation with the rebel groups in Darfur for the Darfur peace agreement, when I spoke to those in Eastern DRC engaged in the work of militias attacking civilians, the mention of the International Criminal Court, the fact that investigators were at work, the fact that charges might be brought and that those people might end up in The Hague was a powerful, powerful instrument in bringing them to the table. So the ICC is well known. Its existence alone is a deterrent. The fact that an investigation and prosecution might be brought was very meaningful to the wrongdoers on those occasions. I don't say that creating this court is going to be a deterrent against corruption. Of course it isn't. The success of this court will be a deterrent, and that's why we have to work towards its success.
Okay, thanks, Alan. Now I have we're going to move to questions from the floor in a few moments, but I have a couple of questions that are sort of related.
If I might, Roy, just to very quickly pick up on Alan's last point. I think that example, and whatever amount of time it may take, whether it's 10, 5, 2 years, I think the fact that the specter of accountability is real. It's particularly real for those who engage in grand corruption. We're not talking about street crime. We're not even really talking here about cartels and mafia. And there has been massive efforts in those regards for decades around anti-racketeering, and there's been adjustments made to the law. In Canada, we've made adjustments to our criminal justice system. But the public naming and shaming aspect and the exclusion of individuals like Vladimir Putin, the expulsion from the G8, for example, removal of Russia from other international bodies, but the actual accountability for that individual who has headed up a grand corruption stream is powerful in my estimation, as is the seizure of assets. And we have seen, again, a knock-on effect of what's been going on and the sanctions that we're seeing placed on Russia right now, the seizure of yachts. And again, for emphasis, the ability to hide money today compared to just a few short years ago is massive. We've heard stories of hockey bags full of cash being flown in to jurisdictions and laundered through casinos as one scheme, buying houses for cash off the Toronto market. Those things do still happen, but we're talking about even well beyond those type of schemes. We're talking about money that can cripple economies, a percentage point of a national GDP being skimmed off. And individuals that are traveling in those circles travel. And they want to be able to buy soccer teams in London and houses in Paris. Going after those individuals, having them standing in a prisoner's dock, even being named, I would suggest, there is an impact. The fact that we have this on the agenda for discussion today is an improvement. And the more emphasis that we can place on it, the more attention we can bring to it, the more light we can shine on it, what an international anti-corruption court would do, I suspect the word will spread and the fear will creep up the spine of people in many, many countries, knowing that they could be the individual that's caught next. Things like the Panama Papers have shown that it isn't just the usual suspects.
Right.
Thanks, Peter. Some good comments. Yeah. There's a couple of questions from the floor that are sort of related, and it's looking at the linkage or otherwise between grand corruption and human rights. Now, I know when the Global Organization of Parliamentarians Against Corruption, when we took on this project, we tried to de-link them in the sense that we didn't want to be grand corruption competing with mass genocide and sort of creating a link that might make people feel uncomfortable. But we also do know that grand corruption leaves millions in poverty in many countries, in some in abject poverty. Some people are dying because while their leaders are shuffling money off into offshore havens or other international banking operations. So what do you think of the idea of the linkage, if any, between grand corruption and human rights, and how would it affect how people proceed with this initiative like this?
Well, it's not us who are linking it, Roy. It's the world. I mean, there is a linkage between grand corruption and human rights. I mentioned the way I got involved in this subject at all was because I was working with the World Refugee and Migration Council. And I saw the linkage between corrupt regimes and the consequence of forced displacement, either through bad governance or violence and conflict. There is a connection which is integral between corruption and human rights. I mentioned that money gets skimmed off from public health programs, from infant mortality, from Ebola and infectious diseases. That's all got to do directly with denying human rights to health or to life. So we're not making the connection. The connection is made as a matter of fact. And I think if we focus on going after corruption, we will, to that extent, advance the cause of human rights.
I would add to add, Roy, I would add to add what Alan says. I totally agree. And it also makes another point relevant, which is because that is the case, it's not only important to go after those responsible for it, knowing that the consequences are massive violations of human rights, but also to address the consequences of those activities. And to repair the damage that these people are causing. Just go and visit Equatorial Guinea and see the state of the health sector in that country. And it's one of the richest countries in the world, or at least, well, it must be again because of the oil prices. But so it's also a way, it's a mindset, but it's also about the instruments to deal with it. So, and it's also about the policies that we think through. So it's just, we need to stop thinking just about the perpetrators when it comes to fighting corruption, and also think about the victims and the damages they've caused to be able to repair it, which is another issue that is important to bring into this discussion.
Okay, Matthew, I saw your hand up.
Yeah, so the link between corruption and human rights is really interesting. It's important. It's something I've thought and written a little bit about. I certainly don't consider myself an expert, but I just want to make a couple of points here. So I want to distinguish two different ways to think about the link between corruption and human rights. So one is the assertion, which is almost certainly correct, that corruption can cause human rights violations, that the underlying cause of human rights violations is often corruption or linked to corruption. And there are a variety of ways in which this can occur. I don't think that point is in serious dispute right now. There's a second idea that's emerged in the relevant communities, and that's to think of corruption or grand corruption in and of itself a human rights violation. That is, there is a human right to be free of corrupt government. And the idea is different, right? The idea is not just that grand corruption leads to other consequences that are already recognized violations of international human rights, but that the existence of a kleptocratic government is in and of itself a violation of the human rights of the people, even without establishing the connections to specific deprivations of the rights to, or the whole panoply of human rights with which we're familiar. So, and there's a debate about whether it makes sense to frame corruption or the freedom from corruption as itself a human right. There are two potential consequences of that framing. There's a potential institutional consequence. I think this is one of the things Juanita was getting at. So there are existing bodies, including existing international courts, that are human rights courts. And there's a question whether by framing the freedom from corruption as itself a human right, that would essentially allow those courts to address corruption as a human rights issue. There's a whole complicated set of issues about whether that would even be possible, but I'll bracket those in the interest of time. The other issue is whether, as a political or rhetorical matter, it is helpful to frame the problem of grand corruption as a human rights issue. On this point, while I'm very sympathetic to the idea, I just want to highlight that the rhetoric of human rights resonates in different ways in different parts of the world. And in some parts of the world, Latin America is the one that leaps most immediately to mind, but I think this would also be true for the US, Canada, and Europe. Describing an issue as a human rights issue increases its salience and its moral force, generally, not with everyone, but generally. I caution you, though, that there are other parts of the world in which this is not true. East and Southeast Asia is the one that leaps most immediately to mind. So having spent some time studying that part of the world and traveling in that part of the world, I find myself experiencing a bit of reluctance about the impulse to emphasize that not just corruption causes human rights violations, but the anti-corruption agenda and the international human rights agenda are one and are merged. I can tell you in big parts of the world, especially in places like East and Southeast Asia, the anti-corruption agenda is much more popular and commands much broader support than the international human rights agenda, which is in some places still viewed with some suspicion as this kind of Western neo-imperialist thing, where the anti-corruption agenda just isn't, despite claims in some quarters that anti-corruption is this Western neo-imperialist thing. That's just not the way it's perceived. So I don't have an answer to this. I just want to highlight first this distinction between the claim that corruption causes human rights violations and the claim that corruption is a human rights violation. And second, that thinking through the politics of the rhetorical strategy of framing the anti-corruption movement and the human rights movement as the same are complicated. And we need to think very carefully about this if we're aiming for a global audience.
Very good point.
Okay, thank you. Before I take some interjections from the panelists and I see people want to comment, I don't want to get too far along without inviting some brief comments from Olatunji Ademiju, or Addy. Addy is a Nigerian PhD candidate at the University of Victoria in British Columbia. She prosecuted economic and financial crimes in Nigeria for many years. And interestingly, Addy's thesis topic is an international anti-corruption court. Addy, are you there? Can we bring you up on screen? I see your name there. What I'd like you to do, if you could, is comment on how countries in the Southern Hemisphere, because this sometimes becomes a North-South kind of discussion, but countries in the Southern Hemisphere like Nigeria, how would Nigeria respond to the creation of an international anti-corruption court, and how would one deal with any of their potential concerns? Addy?
Thank you for having me on. My PhD research looks at the prospects of establishing an international anti-corruption court from the lens of third world countries. So it is interesting for me to see the efforts that are being made and the reasoning behind the establishment of an international anti-corruption court. If we say that the justification for an international anti-corruption court is the poverty and underdevelopment caused in countries that are most hard hit by corruption, then we would also want to remember that it is important for these countries to get the monies back. So when their wealth are stolen from the countries and hidden in developed countries, we have issues going on that does not seem to be well balanced. I don't know if you can hear me, please.
Oh, yes.
Yes, you're fine. Yes,
so
good.
the third world countries have is the way the anti-corruption program has been couched in terms of what is seen as corruption. It seems that there is a kind of lack of focus on the roles actors in the developed countries play in perpetuating poverty in developing countries. When you look at what is stolen out of Africa on a yearly basis, the estimates, and you look at what is given to Africa in terms of financial aid, you will see that if these monies are brought back to Africa, we will not have to have the loans. We will not have to be in a situation where we are always at the mercy of Western countries. And there is a politics to this as well, which it will be nice for people to start looking at. When Western countries place themselves on a high pedestal, moral pedestal, to point fingers at African kleptocrats that they are thieves, then they should also remember to point the 4 other fingers at the actors in their states that help move these monies, that help keep them. And then they also want to look at the justice system in their states that has served as a hindrance to the prompt repatriation of these monies back to Africa. In Nigeria, there was a joke that was going on that every time the country is broke, the late President Abacha, the late General Abacha, sends us monies from the grave. Why? Because monies that have been stolen are trickling back to Nigeria. So we tend to make concerted efforts when we are broke, but unfortunately, we can't get those monies back on time. So what my research is really about is using a third lens, a third world approach to international law to look at those issues that have been muted in the discussion, in the anti-corruption discourse, issues like who is corrupt, how do we categorize corruption, what do we look away from, what do we beam the light at? Yes, there's no denial that African countries are corrupt. I can even say that they are corrupt in the quantum of money that are said to be stolen can be said to be correct. But what about the other side of the coin? And it seems that the process is tilted in a way that tries to avoid this other side of the coin. For us, you can as well, there is no value to finding somebody guilty, prosecuting without talking about prompt repatriation. And the IACC can have value in this regard. One, the cooperation that an IACC can allow is such that can be very potent for prompt repatriation of funds. When it comes to the offense of money laundering, it is not just difficult to prove because money leaves your jurisdiction. It also involves the multiple jurisdictions that these monies pass through. And there is always a challenge in getting cooperation from developed countries when it comes to following the money. And because you also have to understand that these issues also surround issues of power. African countries are not in the right position to negotiate asset recovery regimes with each country. And that is why we need an international effort to bring these countries to the table in order to talk about how we can get the funds back.
Okay, thank you very much, Addie. I know that Mr. Sani Abacha, the money that he stole apparently is estimated in the vicinity of $700 billion. And as you say, that it has been trickling back through these recovery mechanisms, but it's been a very slow process. One of the issues that organizations like STAR have, and that is, if the money is repatriated, does it go back to a government that is contemporarily corrupt itself? And how do you deal with that? Do you set up a trust fund? I'm not suggesting that Nigeria would misappropriate those funds, but how do you deal with making sure that repatriated funds are dealt with in an appropriate way?
Those are the kind of issues that a third world lens can also speak to. When Western countries point at the corruption in African countries as a reason to retain the funds, they do not point at the same corruption when they loan monies to African countries. Sure. And the loans give them the opportunity to attach conditions that, puts African countries in a tutelage. It allows Western countries to play a tutelage role over African countries, so that there is hypocrisy, even in that insistence that the monies will be restolen. If the monies will be restolen, then you will not have cause to borrow us monies. But every time we're always getting funds from Western countries in forms of loan, and they are always assistant to repay the money. So that shows that there is much more to the politics of asset recovery than what we tend to point out presently.
Thank you, Eddie. Some good food for thought, especially from someone with direct on-the-ground experience with this in Nigeria. Anyone else like to comment or?
Well, I just want to say I'm grateful to you, Roy, for arranging to have Addie's voice in this discussion. It's a very important voice. And I'm so glad to hear the points she made. And I look forward to reading her thesis. I'm sure we'll learn from it. But I wanted to address something Addie said, and that is pointing the finger at a kleptocrat in Africa means we must also point the finger at those who enable that person, and they're often here. And every iteration that I've heard about the jurisdiction of the International Anti-Corruption Court would include in its ambit those who do enable and facilitate the corruption, whether it is the lawyer, the accountant, or the others who, you know, as Peter mentioned, the Panama Papers, if you look at the arrangements made, highly sophisticated money hiding arrangements, surely the court would have jurisdiction to deal with those people as well. But thank you for bringing Addie into this conversation.
Okay, thank you. Anyone else? Yes, Juanita.
Yes, 2 points that Mrs. Adewola mentioned, very important perspective too. One, you cannot expect countries to support and promote this court without doing the work at home. So I would be very careful in checking who is supporting what and who, to what extent countries are doing the right things at home. The things that actually work here and now, beneficial ownership registries, anti-money laundering laws implemented, and high standards implemented. So countries that may be supporting this court that are not doing that, we should raise that question. The other point is the point that Alan picks upon, which is the role of companies and enablers in this whole topic, which we haven't managed to mention yet. I just want to carry it to the other extreme. They not only need to be considered, and I think James Cohen also mentioned that earlier in a comment, they not only need to be considered in this discussion, in whatever discussion about law enforcement and about dealing with kleptocrats. But this is another idea. If Canada really wants to change the trends and wants to change the landscape of international justice, companies need to be made subjects of international law. We still have an international law system of the 19th century built around nation states. The court repeats that model to build a court among nation states where civil society is not involved, where companies are not involved. They need to be involved not only at the formation, in consultations, in bringing in ideas, but more importantly, legal persons need to be subjects of international law. They are not today, and the world is ruled by 5 companies. That cannot, we need to update the model.
Okay, thanks, Juanita. Yes, Matthew.
Yeah, so first of all, I completely agree that it's wonderful that Adi brought these issues up and put them on the table. You know, whatever we think about an international anti-corruption court, with or without that institution, going after the enablers and making sure that stolen assets are returned to the countries from which they're stolen in a manner that will benefit the citizens of those countries is, I think, something on which there would be broad agreement. And the charges of hypocrisy for Western governments are, I think, also well taken. I have to say, though, I'm puzzled by Alan's statement that, of course, the International Anti-Corruption Court could go after the Western enablers, the American, Canadian, British bankers and accountants and so forth, because everything that I've read about the International Anti-Corruption Court proposal declares that it will operate on the so-called principle of complementarity. That is, it will only have jurisdiction when the domestic courts of the defendants are incapable or unwilling to adjudicate criminal charges brought against those individuals, which would not be the case with respect to Canada, the United States, the United Kingdom, France, and so forth. So the enablers will not be subject to the jurisdiction of this court unless the IACC proposal is changing yet again to ditch the principle of complementarity. Second point here, there's one of the reasons that the enablers often escape punishment is the insufficiency of existing laws to get those people. Those need to be changed. That needs to be fixed. However, this creates another difficulty with the International Anti-Corruption Court as the mechanism to go after the enablers, because one concern about an institution like the IACC is, well, countries differ with respect to laws. Who's to decide what activities are illegal, such that the court can put people in jail for them? The traditional answer from International Anti-Corruption Court advocates is there is a core of grand corruption offenses that are illegal everywhere, right? And that are recognized in the UN Convention Against Corruption as illegal, and therefore we don't need to worry about those complicated questions because there's broad consensus that those things are illegal in every country, and so there's no problem. Once we decide we're going to expand the jurisdiction of this court to the so-called enablers, then not only do you run up against this apparent commitment to the complementarity principle, but you no longer can rely on that international consensus. So someone will need to define the nature of the offense and who is that going to be and how is that going to be decided, and I don't know. So I'll come back to where I started. This is why I think there absolutely need to be coordinated international efforts to go after the enablers and go after the money. But an IAC is extraordinarily ill-suited to do that. Whereas, as Juanita keeps saying, we have the tools now. We need to use them, and we need to close the loopholes in the existing law and strengthen the enforcement. But like, that's what I would say with respect to the exchange that just occurred between Adi and Alan.
Okay,
Mike, just really quickly, Roy.
Yeah, I think, Alan, I wanted to, just before I go to you, Peter, Alan, I think should be given a chance to respond to that. Alan, any comment?
Well, thank you. And it's an interesting point. Matthew, I don't at all diminish the importance of complementarity. I think what I say is that if a proceeding were to be brought in the International Anti-Corruption Court against foreign officials who have put money on deposit in Canada, and if, in fact, as part and parcel of the investigation, it became obvious that there were enablers in Canada who permitted that to happen, it may well be that Canada would cede jurisdiction to that extent to the International Anti-Corruption Court as an integral part of the investigation and prosecution, to have them added as parties in that proceeding. So complementarity remains an important principle of the court, but other issues of convenience and the administration of justice also have to be taken into account. And ultimately, it is the domestic legislation adopted under the Convention Against Corruption which forms the legal basis for the prosecutions that will be brought, the investigations that will be carried on. Sorry, Peter.
Yeah, no, thanks, Alan.
Only
Peter,
really to sort of follow along that thread, I think that the drafting and the standing up of the court itself can answer many of these questions. And I would say, as a general response to some of the criticisms, albeit well articulated and with lots of good factual basis, is we shouldn't let the perfect get in the way of the good. This is, again, a process that is going to happen incrementally, and it's meant to buttress existing systems that, I say again for emphasis, are simply not getting the job done. And this discussion, and Adi, I as well want to add to others' thanks and gratitude to you for bringing some of these really practical considerations out, because when you are relying on, let's say, the host nation of corruption to then participate in efforts to bring about accountability and prosecution, and you're going to need extradition requests to be met. You need to warrants, continuity of evidence that's going to be brought before a court eventually. Of course, complicit individuals are not going to participate if it means their president or their bureaucrats or their police or attorney generals are going to be caught up in the scheme. So that's where the weight of an international court. And, again, I come back to this element of trying to drag those before a court, as we've seen in human rights violations and war crimes and leg irons, to put them on display and to hold them accountable. The seizure of assets and the elements of recovery and repurposing, extremely difficult, but you have to try. And the discussion here around what constitutes corruption. And, I tried to get into the discussion earlier because I think that the human rights violations and the necessity to link them, or the flip side, to decouple them, is a bit of a esoteric academic discussion, because I personally think they're inseparable for some of the same reasons, I think, where we all do agree the money being used for a purpose for which it was never intended, taken away from the type of enhancement of rights that we would like to see. One of the worst atrocities that we're facing, beyond many of the other obvious ones, is exploitation of children and human trafficking, which is driven by greed. And like the drug trafficking and other illicit goods, the sale of children for sex, it's mind-blowing, the market that is there, and the fact that this is expanding in the age of the internet. And so that element of how do we attack a problem as atrocious as that, along with all the others, is going to inevitably require a much more coordinated, comprehensive global response. And the court can be the repository of so much of the existing information. We can take much of the discussion that has been placed before us today that is contrary to why we would do it, and strap that on to how we make the court more efficient and workable. Take those arguments at the front end when you're standing it up and say, here's how we improve it. Here's the failings of the existing International Criminal Court. Let's not replicate that, but let's take the best of what they have done and improve the system in a way that it is at least going to result in one individual being brought forward for accountability that will send a message to like-minded.
Thank you so much, Peter. Well put. I'm afraid we're going to have to end it on that point because our closing time is coming upon us. So I've been able to work in some of the questions from the floor to the panelists. So, and some of the follow-on questions that I had planned have come out in the discussion. So, I mean, this is a massive topic. And as Joseph said at the outset, the anti-corruption law program sees this as a first step. So those that are still interested they'll be having some more webinars on this topic, and I ask you to stay tuned to that. I want to thank the panelists for a really fruitful discussion and some really interesting and in some cases disturbing things that I think as a society need to deal with. Now I'm going to have a personal plug from me. And as former US President Obama once said, change will not come if we wait for some other person or some other time. We are the ones we've been waiting for. We are the change that we seek. So just to mention that a recording of today's webinar will be posted shortly on the LinkedIn page of the Anti-Corruption Law Program. Secondly, on the Center for Business Law website. And thirdly, on the Peter A. Allard School of Law website. So now what I would like to do is turn the floor over to Dr. Carol Liao for concluding remarks. Ms. Liao is the director of the Center for Business Law at the Peter A. Allard School of Law in Vancouver, where she is an associate professor. She is a University of British Columbia distinguished scholar and a member of the New York Bar. Ms. Liao, over to you.
Thank you so much, Roy. And I've just been blown away by this insightful panel, and I want to thank our former MPs and stellar experts, Alan Rock, Peter MacKay, Juanita Ole Garcia, and Matthew Stevenson for this incredibly rich discussion, as well as the Honorable Roy Cullen for his impeccable and masterful moderating. Thank you as well to Adi Adebola for her very thoughtful comments to help round out our event. And as Adi said, anti-corruption is really just an intimate, close study of power. Who has it, who wields it, who abuses it, and in particular, this abuse of an entrusted power for private gain that is intentional. And there are real risks in whistleblowing and in every stage of investigating, prosecuting, convicting, and sanctioning corrupt senior officials. And retaliation can be direct and violent, and it can be as secretive and pernicious as the corruption itself, and it can destroy lives. So it's no wonder that many are reluctant to challenge the status quo and the grand corruption found at these highest levels. But that is why discussions like this that we've had on how to best combat that corruption are critically important, because it reminds us of what is imperative for our international community, upholding what is right and just, and that we are aligned in this, right? And recognizing that grand corruption impoverishes societies. It diminishes their capacity to fight climate change, respond to pandemics, foster democratic societies, protect human rights, as we discussed, and ensure a safe, just, and equitable space for us all within our planetary boundaries. So, you know, agree or disagree, these avenues of inquiry on an IACC are very important and are a reminder that people are paying attention and care. So, you know, the anti-corruption law program has been on the cutting edge of anti-corruption law for a number of years now, delivering free, public, and accessible information on this dynamic and evolving field of law. I'd like to take a moment to recognize my dear colleague, Professor Emeritus Joe Weiler, and John Ritchie, Norman Baldwin, and all the contributors and incredible team behind the anti-corruption law program. The conflux of these intersecting crises that we are facing has certainly exacerbated corruption risks around the world. And so corruption prevention, oversight, regulation, and particularly the knowledge that the anti-corruption law program has been sharing and will share throughout 2020 is so important. And so despite the challenges of the past years, this program also brings us together in many ways and has allowed for those connections to continue. And the overwhelming number that have attended this event, which we announced only 2 weeks ago, speaks to that demand and the interest in this type of information and education. So thank you all for coming on behalf of the ACLP and the Center for Business Law, Transparency International Canada, and iClear. If you want updates on upcoming events, please sign up for the Center for Business Law newsletter, which is available online, and certainly as well as our partners, TI Canada and iClear. So thank you again to the panelists and this incredible group, and we're grateful to you all for coming. Thank you again, and goodbye, everybody.